Hello. Welcome back to Module 2, Foundations of American Governance. Today, we will go over Section 8, Auxiliary Precautions. In this video, you will learn how the framers created the means by which the sovereign people can self-govern and prevent tyranny. Built on the principles of equality, consent, and rule of the majority, the Constitution provides the sovereign people with the means for effective and reasonable self-governance. As the sovereign, the people separate the three functions of government into departments and delegate specific powers to each, which protects against tyranny and preserves liberty. To that end, the principle of separation of powers helps the people maintain control of their government. The framers understood that the latent causes of faction are sown in the nature of man. Consequently, the Constitution establishes a number of institutional mechanisms, such as representation and separation of powers, to control the effects of faction. In so doing, the Constitution improved upon previous models of republican government. Sovereignty, if unchecked, can grow dangerous. Power, therefore, must be held outside of the government, yet delegated to a variety of people to perform an assortment of tasks. This delegation can occur at different times. As evidenced by the three federal branches of government, power is separated and equal. The structure of the Constitution underscores this point, as the document is organized into a series of articles. We will discuss the practical aspects of these articles in Module 4. The method by which the framers sought to avoid tyranny was the separation of powers. Separation of powers causes divided government and prevents the concentration of power in the hands of one person or one faction. Montesquieu said, "When legislative power is united with executive power in a single person, there is no liberty, because one can fear that the same monarch or senate that makes tyrannical laws will execute them tyrannically." We've discussed the English Bill of Rights several times already, so you'll remember that the document restricted monarchical power, established parliamentary supremacy and a constitutional monarchy, and guaranteed the individual rights of British citizens. Divided government means that the various co-equal branches are each granted separate powers in order to fulfill their functions. For a legislative power, this means the power to make laws. For executive power, this is the enforcement of laws. And for judicial power, this is the interpretation of laws. Power is further divided by the various terms of elected offices and their specific constituencies. Members of the U.S. Senate are elected every 6 years, and, until the passage of the 17th Amendment of the Constitution in 1913, the constituency of senators were the state legislatures. Since then, senators have been chosen by direct votes of the people. Members of the House are elected every 2 years, and their constituency is the people. The president is elected every 4 years, and the chief executive's constituency is the Electoral College. We will discuss this unique feature of the federal government in Module 5. As you can see, the methods of election spread political authority across the entire country. We mentioned in Section 6, representation of the people, that the elected offices of the federal government could theoretically take 6 years to completely turn over. 3 elections are needed to seat an entirely new Congress, and the occupant of the Oval Office can be changed in 2/3 of that amount of time. This means that authority is likewise spread across time. However, this type of scenario is highly unlikely. Checks and balances are the mechanisms by which political power is distributed throughout government to prevent any one body or individual from exercising absolute rule. Checks are the means by which one branch of government limits the power of others. Balances are the methods by which assorted interests are equally and fairly represented, even those of the minority. We discussed this concept in Module 1, Section 2, when we covered the Roman Republic. English jurist and politician William Blackstone was a proponent of the idea and said, "In the legislature, the people are a check upon the nobility, and the nobility a check upon the people, by the mutual privilege of rejecting what the other has resolved, while the king is a check upon both, which preserves the executive power from encroachments." And this very executive power is again checked and kept within due bounds by the 2 houses through the privilege they have of inquiring into, impeaching, and punishing the conduct, not indeed of the king, which would destroy his constitutional independence, but which is more beneficial to the public, of his evil and pernicious counselors. Thus, every branch of our civil polity supports and is supported, regulates and is regulated by the rest. In the United States, each branch of the federal government has the power to check the ambitions of the other branches. This is true of the state governments as well. Montesquieu observed, so that one cannot abuse power, power must check power by the arrangement of things. This system works with the notion of separation of powers and prevents concentration of authority. Moreover, each branch of government is reliant on the people, who are the true source of political authority. Doubtless, you will be shocked to learn that not everyone has the common good in mind. There have been, and there likely always will be, elected and appointed government officials who use their authority to pursue policies or legislation that align with their own interests rather than the public interest. Madison said in Federalist No. 51 that if men were angels, no government would be necessary. If angels were to govern men, neither external or internal controls on the government would be necessary. As he knew, human beings are imperfect and need a check on their self-interest and ambitions. He further said, ambition must be made to counteract ambition. Madison considered the legislative branch to be the one most potentially dangerous to public liberty. With its power to make laws, the legislative branch could encroach on the prerogatives of the other branches and draw, quote, all power into its impetuous vortex, end quote. To counteract this possible course of action, he advocated for dividing the power of Congress into two separate houses and to keep them separate by different methods of election and different terms of office. One means of achieving this end was to establish that the House of Representatives would be chosen by a direct vote of the people, while the Senate was chosen by the state legislatures. George Mason argued in Federalist No. 62 that selection by state legislatures gave states a means of defense against federal overreach. While the horizontal checks and balances between the three federal branches is crucial, state control of the U.S. Senate served as a second, vertical check on the federal government. During the convention of 1787, William Pierce and John Dickinson concurred and emphasized citizens would, quote, be represented both individually and collectively, end quote. This view prevailed in the end and was ratified in the Constitution as Article 1, Section 3 the next year. The ratification of the 17th Amendment in 1913 altered this formula, and now both houses are directly elected by the people. Whether this has had a positive impact on the country is open to debate. Interbranch oversight is part of the checks and balances that we just discussed, which is designed to ensure that no one branch becomes too powerful. The first is legislative oversight. Article 1 of the U.S. Constitution vested the Congress with its powers, although there is no expressly stated provision authorizing congressional oversight. In several decisions, the Supreme Court has found the power of oversight to be vital to the legislative process, and that such authority was implied in Article 1. In Watkins v. United States, the Supreme Court said that the power of the Congress to conduct investigations is inherent in the legislative process. That power is broad. It encompasses inquiries concerning the administration of existing laws as well as proposed or possibly needed statutes. In Barenblatt v. United States, the court ruled that the scope of the power of inquiry is as penetrating and far-reaching as the potential power to enact and appropriate under the Constitution. And, in McGrain v. Daugherty, the justices observed that a legislative body cannot legislate wisely or effectively in the absence of information respecting the conditions which the legislation is intended to affect or change, and where the legislative body does not itself possess the requisite information, which not infrequently is true, recourse must be had to others who do possess it. Oversight in this context means Congress has the authority to obtain information and to review and monitor the public policy that has been implemented by the executive branch. This can range from formal committee hearings to informal meetings between executive officials and congressional staff members, representatives, or senators. Other activities could be staff studies, agency reviews, and inspectors' general reports. Article 1, Section 7 of the Constitution defines veto power. As an example of this usage, the President receives a bill passed by Congress. For whatever reasons, he returns the bill to the House of Congress from which it had originated. This is called a regular veto. That veto can be overridden by a two-thirds vote of both houses, which is yet another check on power. Additionally, the Constitution specifies that the President must sign or veto a bill within 10 days, excluding Sundays, or it will become law. This prevents the chief executive from allowing legislation to die through inaction. Conversely, if Congress adjourns before the President acts and the 10-day limit ends, the bill does not become law. This scenario is called a pocket veto. Article 3, Section 1 of the Constitution established the federal judiciary, but the Constitution did not expressly grant the courts the power of judicial review. The framers who expressed an opinion on the matter were in favor of judicial review. Writing in Federalist No. 78, Hamilton said, "The interpretation of the laws is the proper and peculiar province of the courts. A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between two, that which has the superior obligation and validity ought, of course, to be preferred, or, in other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents." Article 6 established the Constitution as the supreme law of the land. Judicial review was eventually recognized as a doctrine in the decision of Marbury v. Madison in 1803. Thus, judicial review is defined as the ability of the courts to determine whether a legislative or executive action is contrary to the Constitution. If so, that action must be declared unconstitutional and struck down. Representative government and the consent of the governed, which we have already covered, are yet more important checks on abuses of power. Dividing power in all these various ways instills patience and deliberation into the process. As you have likely noticed, there is no one provision that achieves the goals of the Constitution. Rather, the entire structure is designed to channel power for the common good. Lastly, the structure of our entire federal republic is a series of checks and balances and separations of power. Writing in the spirit of the laws, Montesquieu said, "In each state, there are three sorts of power: legislative power, executive power over the things depending on the right of nations, and executive power over the things depending on civil right." Montesquieu's ideas of separation of powers inspired the federalist structure, with distinct legislative, executive, and judicial domains. Federalism divides constitutional power between a central authority and regional governments, ensuring both unity and autonomy. The Federalist system of the United States was a remedy for the drawbacks of the Articles of Confederation with its weak central government. The national and state governments have shared responsibilities and defined powers within their respective jurisdictions, but neither has absolute control over the other. This is also known as dual sovereignty. Madison, writing in Federalist No. 46, noted that the federal and state governments are in fact but different agents and trustees of the people, constituted with different powers and designed for different purposes. Federalism balances national coherence and consistency of policies with local flexibility that addresses specific needs and special circumstances. Supreme Court Justice Louis Brandeis appreciated the benefits of federalism and popularized the notion of states serving as, quote, laboratories of democracy, end quote. In New State Ice Company v. Liebman, the justice observed how a single courageous state may, if its citizens choose, serve as a laboratory and try novel social and economic experiments without risk to the rest of the country. This idea recognizes the fact that what is good for Kansas is not necessarily good for Maine or Arizona, and vice versa. Instead, each state can work on creating the best solutions for their citizens when confronted with complex challenges. Other states may then emulate or adapt the results for their own constituency. This has often proven to be a better model for solving problems than a one-size-fits-all answer from the federal government. By distributing political authority, federalism prevents the abuse of power. Hamilton explained in Federalist No. 28, "The general government will at all times stand ready to check the usurpations of the state governments, and these will have the same disposition towards the general government. If their rights are invaded by either, they can make use of the other as the instrument of redress." When we focus more on the Constitution in Module 4, Section 1, we'll talk about the 10th Amendment and how it furthers federalism. Next time, in the next video, we will talk about the restraint that comes from self-government by a virtuous people. Until then, thank you for your time. If you want to learn more about the subjects we have discussed, here are the sources used for this section.